Hello and welcome to Fire Away, Rudner Law's online Q&A show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator and your host of Fire Away. Just a reminder, Fire Away streams live online every month. Past episodes are available on YouTube, on our Facebook page, and on our website. If you are watching live and have any questions, we'd be happy to answer them. So please either post a comment on Facebook or YouTube or tweet to @RudnerLaw. As usual, we have a guest today. Today, we're joined by Eric Poirier. Eric is the Health, Safety, and Environment Advisor and Investigative Consultant, as well as being the founder and director of Argus Research Group. And our topic today is investigations, what investigation means, what policies and procedures should be in place, what do you do at the end of the investigation, what do you do with the results, and how do you move forward? And we're probably going to get into that and a whole lot of other issues regarding investigations. So let's get to it. Eric, thank you so much for joining us on Fire Away.
Thank you, Stuart. Appreciate the invite. It's an honor to be on Fire Away with you today.
I'm looking forward to the discussion. We've known each other for a little while. I know that you like doing investigations, and I know you do a good job and you take it very seriously. Our theme today is, so you have to conduct an investigation, which is often, words that HR folks dread hearing. And especially in the last couple of years, investigations have become a huge part of HR and employment law. I can tell you, many viewers will know this already, I lead a course put on by Osgood Professional Development. The course is called HR Law for HR Professionals. It's a 5-day certificate course. And when I first designed that course about a dozen years ago, investigations were a footnote of one small section of that course. They're now one entire day out of 5. So that just gives you an idea of how important it is for organizations to get it right. And at the same time, it also mentioned my book, You're Fired, where we talk about just cause for dismissal. And I read every single just cause decision. And I see the judges and the arbitrators over and over again looking at what was done in order to investigate before steps were taken, before dismissal was undertaken. And if there wasn't a proper investigation, courts are extremely, extremely critical. And the last thing I'll mention before, Eric, we get to you, in my mediation practice, I'm seeing a lot more disputes these days where either there was no investigation, and because of that, the plaintiff is seeking additional damages, or there was an investigation, but it was really a prosecution in all but name, where the decision was made before they even started. So there's a lot of ways that employers can get it wrong. But let's take a step back. Eric, from your perspective, when are investigations required or when are they advisable?
Anytime where there's a non-compliance issue or there's a suspected or an alleged non-compliance issue with respect to any sort of policies, procedures that the company has in place, any sort of legislative requirements, and any perceived allegations or a thought of any sort of fraud in the workplace or employee misconduct. I'll just give an example, I guess, with respect to, let's say, a company vehicle or a company property. You have a company vehicle, then the company's got to have a policy or should have a policy in place with respect to how that employee conducts themselves and how they operate that vehicle. Any sort of reporting procedures with respect to any motor vehicle collisions that they may or may not get into. Their conduct and behavior while operating this vehicle on and off the job site. You can get into a myriad of situations that put the company at risk with respect to having that employee being responsible for that vehicle on the road. You're looking at Highway Traffic Act violations. You're looking at a really big PR symbol, basically, essentially, for the company being on the road. And if there's any sort of incident, if it's not reported and the company doesn't know about it, and then it comes back a few years later, or let's say 16 months or 18 months later, and the company gets a notice that they're being served with a document saying that they're being sued, or there's legal action being taken against them as a result of a vehicle that comes up or was discovered that they owned, but they no longer have this employee there, then they're stuck investigating and trying to figure out what happened there. If they have a policy in place and it wasn't followed, and they can track that vehicle back to the employee, then they could sort of look into that. But if that what if they can't get a hold of that employee, then they're stuck with that risk and that liability there. So it's important to understand that and educate them on company property and the policies and procedures that are related to it that meet or exceed the legislative requirements that relate to that operation. So that's just one aspect of it. And then you've got, let's say, fraud, for example, or they're paid for a certain amount of time and they don't show up, but that's not monitored. Those are things that are very serious, but if they're not investigated properly and we don't do our due diligence to support the investigation with proper facts and documentation, trying to dismiss that individual, although it is a very serious situation, trying to dismiss them if we don't have those facts in place, it could come back to us and not be favorable for the employer with respect to any sort of due diligence defense.
Yeah, that's a critical point. And I know, speaking for myself and probably for the entire employment law bar, one of the things that we find incredibly frustrating is we'll have an employer-client call and say, we need to fire so-and-so, or even worse, we've already fired so-and-so. And when we ask them for the documentation in support of whatever they are alleged to have done, there's nothing. And so we have to then educate our clients on the risks of going forward. But to your point, they should have had proper policies in place and procedures in place to gather data, because investigation now, it's like HR is horrified when they hear the word, because they think it's going to be this long, expensive, extensive procedure, and sometimes it will be, but in many cases it might involve just a brief review of documents. It might involve a brief interview of two people and an email summarizing the findings. So investigations can take many forms, and I want to come back to that with you, Eric, but to your point, there needs to be some documentation. And even if the employee is long gone, I've also had employers who say, oh, well, I know we should investigate, but the person's gone, so I guess we're off the hook now, right? And of course, the answer is no, especially if there was an allegation of harassment. And that's where, we're seeing a lot of investigations, and especially in Ontario under Bill 132, there's an absolute duty to investigate any allegation or even suspicion of harassment. And yet I still have employers who will call and say, after I explain to them that they have that duty, that they must investigate, I'll get a call back with a triumphant call, say, from the employer saying, great news, the complainant left, so I guess we're off the hook now. And I explained, no, A, legally, you still have to investigate. B, even if you didn't, you have an entire workforce that's still there. And if you have a harasser, you still need to deal with this. So these are all parts of the policies and procedures, but also training. People just need to understand when they need to investigate, and the fact they can't just ignore things, even if the person's gone or there's no policy in place.
Yeah. And I completely respect I completely respect that. And to that point, having that training, and part of what I like to do is to help them be proactive with that. Like, let's identify what your policies and procedures were, or what they can be, before we get into any further activity with the business, especially when it comes to harassment allegations, bullying, intimidation. Address it immediately, pull those people aside, collect it. It could just be, a simple conversation one-on-one saying, hey, you know what? This is part of our policies. Maybe you missed it. Let's just have a talk, and we'll make sure it's documented. So that way you're doing your due diligence there. And then moving forward, if it happens again with that same individual or the same individuals, you can come back to that conversation you had previously and move ahead with it and find solutions to those problems. If it's just an outright blatant disregard for that previous conversation that you had and those policies and procedures that are in place, again, it could be very serious, and it is very serious, but it still needs to be handled very delicately and documented properly. You can't just say, well, or you shouldn't just say, well, this was, this is a huge violation of the rules. It's a cardinal rule violation. You're gone. And then,
and I know the title of our show is Fire Away, but in that context, you need to proceed with caution. You're absolutely right about that. And it's funny because I'm doing a seminar on Friday with some colleagues at an HR firm, and it's called The Art and Law of Feedback. And it's all about what you're talking about now, the need to give feedback, but also document. Because again, it's the worst possible scenario is when we're called upon to assist a client and assess, do they have just cause to fire someone? And I go through the file, and all I see are the annual reviews, which say meets expectations and nothing else. So documenting, and just to take a step back, so we're talking about investigations. You've given a few examples, but there's so much of a misunderstanding out there as to what it means. And a lot of people think investigation means something that will cost them tens of thousands of dollars and for months and months. But maybe you can explain, what is an investigation, and perhaps more importantly, what's the purpose of the investigation? Why are people doing them?
Well, from my experience, they're related to an incident or an event, whether they're planned or unplanned. It's a response to figure out and to discover facts with respect to that incident and things that surround that. So whether they're environmental factors, they're personal factors, or they're things that are beyond our control, but it's things that we need to fully understand in order to collect the facts and really provide, I call it an intelligence profile to our customers or to the client, and let them know what the reality is of this of the incident or the event that occurred, whether it was a harassment incident or a motor vehicle incident. Collect the information, gather that evidence, create the intelligence for them so that they clearly understand what transpired in that event, in that moment, and then they can make that decision on what they're going to do there.
Yeah, and that's perfect. And that's, we can work together. Is, often what will happen is an employer suspects misconduct. They suspect that they have somebody who took product out of the warehouse, or there's an allegation or a complaint of harassment being made. So the first step is figure out what actually happened, and that's exactly what you're describing. You would come in, do the investigation, reach a conclusion, which is one of my pet peeves, is investigations that end with I cannot reach a conclusion. It's a credibility issue. So you've got to reach a conclusion. And then once that conclusion has been reached and you find, for example, that the person did engage in misconduct, then it falls to me to advise the client as to what the next steps are and what their legal rights are based upon those facts. Before we can give a proper opinion as to what the client's rights and obligations are, we need you to reach that conclusion as to what actually happened. Yeah. And one of the things I mentioned I wanted to come back to, because, and we often see a lot of amateur investigations, probably more of a pet peeve for you than for me, although it frustrates me as well, because often, especially, I guess we're now in the post-Me Too era, a lot of allegations of harassment, and I still see harassment investigation reports that conclude with, this is purely a matter of credibility, and I cannot reach a conclusion as to what happened. How do you handle investigations where it's really a classic he said, she said?
That comes down, that's difficult. Actually, that's a very unique situation to navigate. So I guess I'll sort of pretext that with, we'll get the employer that will ask us, for example, and I'll make that clear right away at the onset, is, are you wanting a set of recommendations? We can provide that. If they don't want it, then we'll just simply provide them a conclusion. With respect to a unique situation like that, it goes down to how the interviews are really conducted. And maybe I'm jumping ahead here when I discuss this, but the interviews are key and crucial and super critical with respect to gaining really good information. If that interview with whether it's the alleged or the victim, if they're not conducted properly, then you could really obtain information that is so convoluted that it doesn't support the case that you're looking for. Often some people are looking for an admission as opposed to looking for the truth. They already have a set idea in mind with respect to what they want the outcome to be. But that's not the mindset we need to be in when we're doing an interview or an investigation with an individual. We're looking at trying to approach it with a fair opportunity to respond and to be able to provide us with the truth and the information there. That will help determine culpability and non-culpability. However, it's hard to decide if you don't have any sort of video evidence, if you don't have any position evidence with respect to that allegation. It's hard to make that decision, but that's where the interview comes in. Doing a really good investigative interview could be the key to unlocking that truth and providing and supporting the argument that you're going to make with respect to your recommendations. At the end of the day, those people that are in charge of making those higher end decisions are going to take that and make that decision on their own. whether it's going to be under the advice of legal or their own choices. But the interview, I think, in my mind, with respect to your question there, is key to really understanding that and being fair and impartial during that interview. More of a conversation management style, cognitive, building that rapport, making sure you've got that trust, you're totally respectful, and you're not making any assumptions or allegations during the interview is very, very crucial.
Yeah, no, that's a great summary and really helpful. And I've heard, stories about investigations that are entirely biased. I've also heard of stories about interviews that are essentially interrogations as opposed to interviews, where there's a mindset and a predetermined outcome, and they're just trying to get the admission and essentially bullying the person into saying what they want them to say. And that's usually when it's someone who's not trained in investigating. It's the owner of the company who goes in and meets with the person without any training as to how to do it. And that's usually when it gets to my desk. And that's the worst case scenarios, are where a company that suspects misconduct acts hastily. Either they fire the person or they have a sham of an investigation, then fire the person, and then they face a wrongful dismissal claim. And at the end of the day, they end up on the hook for not only severance, but bad faith damages, as well as their legal costs and everything else. So it costs them sometimes 2 or 3 times what it would have cost them just to let the person go without cause because of the way they conducted themselves. So I wanted to bring this back, I guess, to Beth, because I think you can teach a lot of our viewers as to what should and should not happen in an investigation. So maybe at a general level, what would you say are some of the most important things that that people should bear in mind before they conduct an investigation?
Consider all the possibilities first and foremost. You've been made aware of an allegation or an incident that occurred. Don't approach it with a blame idea, with the blame mindset. Don't be myopic either. So consider all those possibilities on where the aggravating factors, the possibilities, the people involved, whether it's let's say a big job site, equipment involved, whatever is there, the environment. Consider that and make sure you understand that and collect that information prior to going into it. It's super important to approach that questioning period and have a planned outcome. And I don't see, like, not a planned objective, because you want that truth, but a planned procedure, sort of checks and balances that you understand that you need to follow. And if something sort of veers off course, then you can bring that back in and you don't go off topic with them. Like, you want to stick to the point and not get trapped into being, I guess, pulled into the story that they want you to follow, right? So it's hard. Like, it's hard. I completely get it. It's hard from an employer's perspective to go in because they have their business to run, and I get that. And it's uncomfortable to have somebody come in, whether it's the HR or the managers come in and do an investigation, sort of disrupt that workplace environment. But it's super important to make it comfortable for them and not to get trapped in an idea that they want you to follow. You have a plan and procedure in place, follow those checks and balances, and stay on target and not get influenced by somebody else's preconceived notions and biases with respect to a specific individual or working environment or a place that they're working in. I don't mean, like, I'm not saying not to have those risk assessments done with respect to those specific environments, but just take those into consideration and don't allow that to force your judgment in any way.
In terms of logistics, do you typically write out a script of questions before you start the interview?
I like to. And depending on the style of interview that we're going into, I like to use like I said, a cognitive style interview. So I like to have it sort of free flowing and have a monologue and dialogue sort of set out and continue that and just allow the individual or the interviewer to speak. That's where you get all the information. I'm not, and again, there's every interview is unique, and every investigation requires a specific type of interview that goes in. The ones that I've been mostly involved in are the cognitive style, and that's where they reveal quite a bit of information. You build that rapport with them, And there's a time and a place for these sort of direct questions to sort of prompt and challenge them on evidence that you've already collected, to ensure, to either A, prove your theory or disprove that allegation or the theory. But there's a time.
You raise a really interesting point. So I think a lot of people assume that like the investigation is a linear process. You interview person A, person B, person C, person D, and then you reach a conclusion. One of the pieces of advice I often give our clients if they're doing the investigation is there's nothing wrong with going back. So if the complainant says that an incident happened in the lunchroom on April 28th, and you meet with the accused, and the accused says I was on vacation that day, there's nothing wrong. And in fact, you probably should go back to the complainant and put that to them. But how do you handle things like that?
I'm pretty straightforward with that. I say that I need to speak with that other individual. And look, like there's some investigations or interviews that I've been in where they've lasted 4 hours. And during that time, it's been the interviewee talking the entire time. And I'm finding out that there were many more witnesses that were present during that period. Some employers and clients don't want to hear, hey, I got to see, another 6 witnesses to really determine what happened here at this location. And some are very, very cooperative, and some are just like, no, we want to know what your recommendations are with respect to this one individual. Well,
sometimes it's a fine line, because part of your duty or part of the expectation as an investigator is that you are thorough, which means reviewing all the relevant documents, interviewing the relevant witnesses. But it doesn't mean going on and talking to everybody.
No.
And the perfect example, I'll kind of put it to you as a question. If you meet with someone who's accused of, sexual harassment, for example, and they say, oh, you've got to talk to Jim, Mary, Sally, etc., they will tell you that I would never do anything like that. Would you bother meeting with those people?
Yes. That's just a classic, like an affirmation. And that gets into the investigative interviewing styles. There's certain behavior that you can see, and there's certain ways that people answer questions. Like with respect to that, if that was a specific incident, then yes, I would want to speak to those people. And simply because of the severity of a sexual harassment case, you really want to make sure you've got that stuff dialed in, narrowed down, and your facts are really put together there. In that specific case, yes, I'd absolutely want to speak to these people. It sort of sets a tone for the character in the background, and
right.
It is surprising and revealing when you get people talking on how much information comes out.
I mean, and it's interesting, and I asked you that, I have to admit, expecting a different answer, because I've had a number of investigators say, no, we don't. If it's a purely character witness, if they don't have nothing relevant to say about the incident in question, I won't do it. But like a lot of things, and I'm going to ask you about notes in a minute, different investigators, different approaches. Now, at some point, if you had a list of 17 character witnesses, would you meet all of them, or would you kind of cut that off at some point?
I would sort of sit down with whoever the client is and ask them, what do you want to do? But give them the basis and who, if they're privy to the outcome or the information that was revealed during that initial interview, and discuss that with them and look at the options. And again, sexual harassment is a pretty severe, a pretty serious investigation that needs to take place. I want to be sure and make sure that if they're not involved, then we've checked that box and we've made that happen, and we've done it properly. But if they are involved, it warrants further discussion, right? So I guess it's unique. Like you can say yes and no. Do you want to waste all that time? I personally would put that up to the employer, but I wouldn't be. I wouldn't hesitate to bring up that recommendation to say, look, maybe you should probably look at this, but let's think about it a bit more, discuss it, dial it in, and figure out who we want to talk to first.
Yeah. Well, and I think that's a really good answer, and it kind of gets back to a point I often make, and when I get a chance to fire away in a few minutes, one of the points I'm going to make is having a very clear investigation plan is important. But part of that is going to be that you have to adapt. So when you meet, anybody you meet with, they're going to hopefully give you names of relevant witnesses. They're going to provide you with documents. You're going to have to review all those, and you're going to adjust your plan accordingly. So I think that's actually a great answer to say, if I get all these names of people, I'll assess whether there's some merit in meeting with them. I'll meet with the client, see what they want to do, because you have to have a plan, but it's got to be adaptable. One thing I wanted to come to, and then we're kind of almost running out of time already because these things just fly by. But the other area where I get, everyone has their own approach or perspective is note taking. So I know some people insist that they handwrite all their notes. Some people bring a laptop. Some people will bring an audio recorder, or it might just be their phone. Some people like video recorders. What's your preference in terms of recording the interviews?
Whatever the customer's going to want. I'm comfortable doing either one. Of course, with respect to the the approval of the interviewee, and the confidentiality and the privacy reasons, if they allow or they agree to a video recording with audio, that's probably one of the best ones that you're going to get. Video doesn't lie, the reaction's there, everything's documented verbatim. But if they don't agree with it, then we have to resort to other methods, which is I like to write verbatim, and then have them review it and initial and sign each page, make sure it's all dated and signed, and they fully understand that this statement is going to be at some point, or can be at some point, reviewed for legal purposes. So it becomes a very serious document that is going to be questioned. So verbatim is always the best in the words of the interviewee, and then get to sign and check that. You can type it too. Typing it doesn't give it the same authenticity to me. Some people love it. How do you get them to check that and make them copies and initial mistakes and that sort of thing?
I've had people, look, I know personally that if I was to handwrite things, I would never be able to read it later on. So for me, that would be a non-starter.
Yeah.
But
I like to handwrite it and then transcribe it into a typed method for the client.
Yeah, which makes sense. But I know some people who also use a laptop, but they will, while the person is still there, they will print every page and have the person mark it up, sign it, initial it, etc. So to your point, but you want to have that done before the person leaves.
Yeah, and you want to decide that before that conversation happens, right? You want to make sure that that individual agrees to it, and that's what the client wants, and you go from there. And that's a predetermined sort of method of documenting the interviews.
All right. Well, sorry about that. That's what happens when you try to live stream your show. While Windows continues updating on my PC, we're now back up and ready to go. They can try to silence us, Eric, but we will persevere. So thank you for your patience.
Not a problem. Not a problem.
So I know we were talking about note taking. There's, I think every investigator's got their own views about handwritten, laptop, audio recording, video recording. You've talked a bit about that. I know some people, like myself, could never do handwritten notes because no one, including myself, could ever understand them. But they will type them out, print them, and get the interviewee to initial or make changes or corrections before they leave the room, which is really what you want, is you don't want the person to leave without confirming your notes of what they said. Is that fair?
That's absolutely fair, yes. And also it continues that rapport-based strategy and that continuum and that management of the conversation you have there too. Should there be any follow-up with respect to that investigation, you've left that door open, you left them comfortable with that, right? You're not hiding anything from these individuals. It's being completely open and transparent. And really, it's just depending on the environment that you're working in with respect to what the client's going to want and they expect with respect to the documentation of that investigation or that interview, and what is going to be accepted by the interviewee. If they don't want to be recorded, audio or video, then we work around that. If I write it verbatim, then I'm going to transcribe it in a typed manner for the client to be able to read it properly, and they'll have a scanned copy of my handwritten notes as well. So they're going to know that this is based on the facts that are being provided from the interviewee. So,
how often do you have people object to audio or video recording?
I've only asked or started recently asking people to do the audio and video recordings. So right now I'm batting 100%. So I haven't had, and I'm sure I will at some point, but so far, and they've been great. Make them feel as comfortable as possible. And as the interview progresses, they forget it's there. And so do I.
I've had so many people say that to me over the years that, they very, as you said, they're transparent. They tell the person, I am recording this. And often they say the person is a little bit uncomfortable for the first minute or so. And like you said, they forget. And you get a great, I mean, your verbatim notes are obviously great, but I think it's even better to have voice or video is the ideal. And that's the standard. I mean, in the States, when they do depositions, as they call them in the States, they're all video recorded now. And so you get, it's almost as good as being there, as opposed to handwritten notes, which are still more common here, which, it's better than nothing, but you don't get the facial and body reactions or the body language or anything else.
Yeah, and you get to see it from the interviewer and the interviewee. You get to see how the interviewer is treating the interviewee, how, if it's conducted fairly, and the way that that information was obtained. So there's a lot of extra value to a video recording and to a video interview where the audio is there and everything's captured. I'm not saying that it's not good to handwrite them, but you capture much more on how that information was obtained during the interview. There's less of an allegation of an interrogation, so to speak, like we were mentioning before.
Well, and that's a great point too, is you protect yourself. If someone's going to allege that, you bullied them into signing this document, you have a lot more protection if you have a video of exactly what happened.
Exactly. And then you also have a video of the conversation management being open, saying, look, we brought you in here for this. You understand why you're being interviewed. And then going forward near the end of the interview, are you okay with talking to us again? Or how do you feel about what's going to be happening next? Or you can, when they ask you, this is what's going to be happening next, and so on and so forth, somebody will be in contact with you, right? So all that's captured right then and there. So there's no dispute in at the end of the day.
Yeah, and I think that's really important. So one more thing I'll ask you, and then I probably should let you get going. I'm laughing. I'm looking in the background. I see Windows update has finished, so we're all good to go again. But we'll finish this off on my Chromebook. Credibility. Like I said earlier, I mean, a lot of the investigations that I am dealing with now are allegations of harassment. There's often no documentation. There's no video. There's no independent evidence. It often comes down to the complainant and the accused, and there may not be much more. So what do you do? How do you assess credibility at the end of the day?
I think that goes back onto historical, history with that employee, that balance of probabilities with respect to both individuals. Do we want to bring in a sort of character background into that? I'm not sure. But that's going to go down to, again, a really good interview and trying to figure out the culpability and the validity of the statement that they're giving you, and sort of assessing the past employment records of this individual. How long have they been there? Is this something that sort of just come up and it was a lapse in judgment? Was it something that they've been hiding for a longer period of time that we just didn't know about, or is the complainant of the character that would do something like this untruthfully and sort of just to place blame? Like, what's the culture like there? There's that environment's very unique, and it can be very challenging to navigate. So I don't know that there's a cookie cutter answer or hard and fast answer to that question, because it's really hard to say. How I would handle it is look at the balance of probabilities and look at that historical value with respect to both individuals, right, and then come up to, here's what I think, based on what I've learned so far. This is what I think have happened, and the evidence strongly suggests that this did occur, or right, the complete opposite. But again, it's hard. It's hard to go about that if there's nothing there to corroborate it with respect to position or video evidence.
It is. One thing I often say to people is, if you're taking on the job of investigator, that's your mandate, is to reach a conclusion. And you made a really important point there, which is, this is not a criminal prosecution. The standard of proof is not beyond a reasonable doubt. It's a balance of probabilities. In other words, what's more likely to have happened, or what's more likely than not. So I see too many cop-outs where people say I couldn't reach a conclusion. But to your point, I mean, sometimes someone's story will be internally inconsistent. They're adamant that it happened on a certain day, when it's clear that it could not possibly happen then. Or sometimes it's just not consistent with your knowledge, with your understanding of the world and the workplace. But there's lots of things that you as an investigator should be using to reach that conclusion as to who is more credible if it's coming down to an issue of credibility. So that's your job, and you're obviously trained at this. Where I get concerned is people who are just, it's often HR, and it's often someone who's never been trained on how to conduct an investigation, let alone interview someone. But the powers that be decide they don't want to pay someone externally, so it's added onto the person in HR's desk as to something else they have to do, and they have no idea how to do that.
Yeah, and there are some very powerful and some very, very knowledgeable and great investigators that do HR. I've met quite a few of them, but it is like you said, sometimes it's rushed too much, and not being like having the ability to sort of say, look, I need more time, and I need to speak with this individual again to really assure and to make sure that I'm right here, because I want to make sure I get you the truth and not the answer that you're looking for.
Right.
And you made a good point with respect to that sort of that culture thing, and not get eaten up with respect to the decision or the recommendation you're going to give them at the end, that you're not feeding in, or you're not making that decision based on the culture and that environment that they're operating in. So our job is to be able to get the truth, get them that information, and help them with their due diligence defense and move ahead. And that's all the balance of probabilities.
And due diligence is probably the important point that I should come back to, because at the end of the day, if there's ever a court challenge or a challenge before a tribunal, whoever did the investigation is going to be on the hot seat. They're the one who's going to be cross-examined as to what they did, what they didn't do, how they reached the conclusion they did. So you've got to be able to justify that. And part of that is good note-taking, good record-keeping, reviewing and reciting exactly what you reviewed in terms of documents, which witnesses you met with. And that's what I often remind our clients of. It's a report doesn't just mean a conclusion. It actually means all of the evidence and reviewing exactly how you got to that conclusion. Right. Because that's how you need to justify and basically defend yourself if you're ever challenged.
That's correct, yes.
So I think that's probably all the time we have. Thank you for your patience during all of the technical issues. And I have to say, Eric, I said it before we started, I love your background. I've been holding myself back for the last 40 minutes from talking about hockey, which we'll have to do another time. But thank you for joining us. And for anybody who wants to learn more about Eric and Argus Research Group, check out argusresearch.ca. And Eric, thanks again for joining me today.
Thank you very much for the invite, and I look forward to future discussions.
Absolutely. We can talk about hockey and maybe some investigations as well.
Yes, absolutely. Look forward to those. Love those.
Sounds good. All right. Rob, are we good for me to fire away? All right. Well, I've just finished recording season 2, episode 10 of Fire Away with Eric Poirier. We talked about investigations at some length. Today, really what I want to discuss is the fact that despite the fact that we've had a lot of discussion, a lot of media attention on investigations, we've had a number of court decisions in the last couple of years, employers still either fail to investigate or fail to investigate properly. And what I mean by that is usually it's a sham investigation. It's really more of a prosecution with a predetermined outcome. And when employers do that, they expose themselves to substantial liability. By way of example, a manager suspects an employee is taking product out of the warehouse. Instead of investigating, they just go ahead and fire them for cause. As a result, the company is now being sued for wrongful dismissal. And ultimately, the court finds that there was no proper investigation. There was insufficient evidence to warrant summary dismissal. And the company has to pay not only severance, but bad faith damages, legal fees, and everything else that goes along with it. In other words, if they just let the person go without cause and given them severance, they would have been far better off. Or perhaps a more timely example in the post-Me Too era is an allegation of harassment or sexual harassment. And the company decides, we're not going to investigate, we know what happened here. And either they fire the accused right away without an investigation, which will get them into the same situation I discussed a minute ago, where there's basically a premature firing, or even worse, they don't investigate the allegations of harassment and allow the people to continue working together, in which case they'll probably face a claim that they permitted harassment to continue in the workplace despite knowledge of it, thereby exposing the person to a toxic work environment, to an unsafe work environment, and ultimately exposing the company to a significant liability and also really bad publicity. The last thing you want as an employer is to be in the media as someone who tolerates harassment and was made aware of ongoing harassment and chose to do nothing to protect the employees. If you want to be an employer of choice, that's the worst way to go. So in terms of investigations, and I mentioned this in season 2, episode 10 of Parkway, they're becoming a huge part of HR and employment law as we go forward. As many people know, I originally designed a course called HR Law for HR Professionals about a dozen years ago now. It's a 5-day certificate course offered in Toronto and online. And investigations at the beginning were one footnote of one part of the course. They're now one full day out of 5, which gives you a sense of how important investigations have become in the modern world of HR law. And the fact that if you get it wrong, you expose yourself to tremendous liability. So what I want to do before we wrap up is go through my top 10 tips. My top 10 tips for handling investigations in the workplace. Number 1, investigate every allegation or suspicion of harassment and any suspected misconduct before taking action. Bear in mind, because often when people hear the word investigation, they're horrified. They think it's going to be expensive. It's going to take forever. Investigations can take many different forms, but it's critical to investigate before taking action. I'm very much aware of the fact that the show is called Parkway, but in this context, it's definitely better to proceed with caution. Point number 2, or tip number 2, investigate fairly and objectively without a predetermined outcome. Otherwise, it's a prosecution, not an investigation. Tip number 3, start by developing a clear investigation plan, which, among other things, will include who's going to do the investigation. Will it be somebody internal? Will it be an external third party? Will it be a lawyer, an investigator? Consider things like conflicts of interests. I have a colleague who often says you should never investigate upward. So in other words, if it's your superior, you should not be investigating. Consider costs. Consider the nature of the allegations and the sensitivity there, as well as any perceived conflicts of interest before making that decision. And then as part of developing your investigation plan, review your policies. You may have a policy which says we will investigate within 7 days. And so you need to know what your parameters are before you start. And on that point, review your policies now, because if you have a policy that says, for example, we will investigate within 3 days, change it, because that's not realistic. If you have a policy which says the director of HR will investigate, change it. You need to maintain discretion. Point number 5, or tip number 5, work with your employment lawyer. You probably knew that was going to come up somewhere in the list. I would recommend that it come up very early on in the process. Get your employment lawyer in at the outset to help you develop the plan. And realistically, my preferred approach is that I want to be there to develop the plan. I want to be there to help retain the investigator. I prefer not to do it because I cannot be the investigator and the lawyer. And then I will be there if any issues arise, and I'll review the report at the end. Tip number 6, communicate with the parties. It's amazing how often I hear stories where someone complains of harassment, for example, or they're told they're being investigated for fraud, and then radio silence. They don't hear anything. They have no idea what's going on. They don't know if they're being investigated, if they're going to be fired. And then they get nervous. And the longer it goes, the more likely they are to go to retain counsel and take steps. If you keep them in the loop, you'll be far better off. Tip number 7, review all relevant evidence and record what you reviewed. This gets back again to my discussion with Eric in season 2, episode 10 of Parkway. Make sure to document everything you do, everything you review, and justify your conclusions, which brings me to tip number 8, reach a conclusion. It is not sufficient to say you cannot make a finding of fact. Your job as the investigator is to reach a conclusion. Bearing in mind, again, it's not a criminal prosecution. It's not beyond a reasonable doubt. It's a balance of probabilities, but you must find either that the alleged conduct or misconduct occurred or did not occur on a balance of probabilities. Tip number 8, document and communicate the results. Have a detailed report which sets out everything you reviewed and basically how you reach the conclusion that you did reach. But on the point of reports, you don't necessarily have to distribute that to everyone. And in fact, my recommendation is not to. In my practice, if I retain the investigator through my firm, we keep the report, and we don't give that full report to any of the parties involved. We'll give them a summary, which sets out what the conclusion was. But especially if it's sexual harassment and there are fairly intimate details, there's no reason why the manager, the owner, or anybody else should be reading that. You just need to see the conclusions. But your lawyer should have the report because they're going to make their recommendations to you based upon that report. Which brings me to tip number 10. Once the investigation is complete, work with your employment lawyer to determine next steps. Is dismissal warranted? Some other kind of discipline? Is there going to be training necessary? What should be happening based upon the conclusion, not based upon the allegations, but based upon the actual conclusion. Those are my 10 tips for conducting a workplace investigation. And in case you haven't figured it out by now, at the end of season 2, episode 10, at the end of this little rant, investigations are critical in the world of HR law, and they are a very easy way for employers to expose themselves to tremendous liability when they're done wrong. So that's my 2 cents worth, and you got here today for free. That's all the time we have for season 2, episode 10 of Fire Away. My apologies again for the technical glitches, but my thanks to Eric Poirier for soldiering on and completing the episode with me. Thank you to everyone for tuning in. Our next episode will be on Tuesday, December 17th, just in time for the holidays. And we're going to be touching upon some of the issues that the holidays raise in the workplace, including issues of inclusivity, issues of holiday parties, how to manage liability, all the things that come up at what is supposed to be a very happy time of year, but can cause some very significant issues in the workplace. That's December 17th. In the meantime, if you have any questions, feel free to email us at info@rudnerlaw.ca. Reminder, past episodes can be found on YouTube, on our website, and archived on Facebook. If you like our page or subscribe to our channel so you get notifications when the episodes are live. I will invite you, as always, to keep in touch with Rudner Law throughout the month, not just every month for Fire Away. Check out our blog, our social media pages, and sign up for our newsletter. But as usual, I will remind you that none of that, including our show, replaces legal advice. As I always say, if you think that you might need an employment lawyer, you probably do. So don't hesitate to contact us, and we'd love to talk to you and see if we can help. Thanks to Rob, especially today with our challenges and Windows updating in the middle of the show. Thanks to Rebecca and Mark. And lastly, thanks to Eric for joining me and to everyone for tuning in. Have a great day.